I teach criminal law and criminal procedure courses in law and psychiatry. The last 3 articles that I've worked on, one was a law and psychiatry article about mass shootings and the theory that psychiatry could prevent those because of the terrorist off duty, which is the duty mental health professionals have to warn third persons of possible violence that's been threatened by their patients. And in a lot of these cases, these people do seem to have very aberrant activities and personalities, but by and large they're not patients in the mental health system. So the idea that somehow those shootings can be prevented by warnings really kind of misses the point. I wrote about an Arkansas change in law the last few years that changed the appellate process for petitioners challenging the effectiveness of their lawyers in Rule 37 proceedings. The Supreme Court altered the process to include a first-step appeal to the Court of Appeals. That was a major change for people practicing law in Arkansas. I've also written recently on, and I'm working right now on a problem involving race discrimination in the selection of jurors, principally in criminal trials, and how this is a difficult problem to deal with because lawyers tend to want a jury that they think is going to be more favorable. The Supreme Court wants a jury that does not have any evidence of race or gender discrimination, and so question, how do you get that? And one of the things I'm writing on is possibly the need to just eliminate what's called peremptory challenges, where the lawyer can strike any juror for whatever reason, but under the Constitution, not based on race. So as long as the lawyer gives a reason that's race neutral, like I didn't like this individual's hair or their demeanor or their answers to their questions, that can get them around the problem of using race or ethnicity as a basis for their strike. The function of the law professor is often simply to describe what the law is or how it's changed to a reader, or to engage in a critique where the professor will say, this is a problem in the way the legislature's drafted this, or in the policy behind this legislation, or they'll look at the court decision which has interpreted the legislation in practice, and they will critique what's happening. And then often it turns out that lawyers in professional teaching have a unique role in basically discussing the future of the law. And if you think about it, over the past 50 years, the amount of technological change that affects our lives and social and economic and political matters of daily life has been incredible. And so what happens is, with the increasing emphasis on technology and the development of the internet, the development of science related to the gene or the genome, you have whole new areas that have never been addressed because there really was no factual basis for worrying about communication online. But when you get the internet being used in a global sense, accessed by almost anyone, you have issues of privacy, issues of libel, issues of assault, issues of freedom of press and freedom of expression that we haven't really had to address in the past. Similarly, look at the technological developments in biology. What does that mean for genetic manipulation? What kind of law should we be thinking about in terms of restricting some of the things that you could do, maybe scientifically? Or outer space. Question, who has a right to declare mineral rights or to own mineral rights on the moon? And lawyers typically deal with problems that exist now. Courts review situations that come up in litigation where those issues are raised. Law professors develop often the theory that will inform legislators in enacting legislation, or the Congress, or courts in deciding cases where there are these issues. It's the law professor in the big scheme of things who has the freedom, the intellectual freedom, to pursue different theoretical positions and advance them in their scholarship. And it's the reason that professional teaching at the law school level is such an incredible gift for people who are concerned about the development of the law. Because in practice, you're concerned primarily with the interests of your clients. In the judiciary, your focus is on things that have happened in the courts that you're reviewing, or maybe in the legislature. In the law school, you get to think broadly, wildly, and sometimes wildly about novel issues or novel propositions about how the law should develop. The thing that's beautiful about teaching in a law school is you don't really have much overhead at all, so you can take a case of someone who has no money but has a good issue. And I've done that because in the later stages of a lot of these cases, there is no court appointment, there is no public money. And a family member calls and says, you know, my son's been in prison for 24 years, can you help him? Every so often you can, and it's very rewarding as a lawyer. People in practice who have to keep the lights going and pay the rent don't have the advantage of being able to take on often those kind of cases, and sometimes they just drain the resources of a law firm. Lots of big firms have taken on death penalty cases that last for years, require tons of hours of work for which there probably won't be enough compensation to cover. They do it because there's a public obligation, but one of the things about being a law professor, in a sense, you are a public resource, and so you can do that. I am particularly thankful to the Bowen Law School. The university has been very supportive of research, and I think these awards are important for that reason. I think the award for service and for teaching there's a trinity in academia of teaching, scholarship, and service, and this reward system basically recognizes that trinity, or whatever you want to call it, and I think that's important. And if you're looking for a place to write and express yourself, you need that kind of environment where there's support for scholarship and research.